Morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, January 15th, 2026 at 9:07 in the morning. So we're beginning our day. It'll be consumed. This will consume our day today on H648, which is a banking, insurance, and securities. It's the DFR, known as the DFR housekeeping bill. Aaron, are you going to join us, or is Joe?
Joe, and I think Amanda's on.
Okay, great. So Joe, if you'd like to join us. Amanda, good morning.
Good morning.
Morning, Joe Valenti, Director of Policy at DFR, and I'll be the cruise leader, or whatever term you want to use, for the day.
Tour guide.
Yes, tour guide, through the housekeeping bill. I have it up. I can share my screen if I have access. So hopefully everybody can see that. And we do have two people from DFR who are here virtually, one from securities, one from legal. In the interest of keeping them on virtually for a relatively short period of time, I thought we could start with the securities sections, which is section 48. We'll go through there to the end, and then we'll start again at the beginning with Aaron. Securities and insurance are both pretty short. Banking is long. It's not as long as it appears. There are a lot of repetitive sections in there, but you can think of it as we'll do securities as the appetizer, banking is the main course, and insurance will be the dessert. So with that, section 48, I will turn it over to Deputy Commissioner for Securities, Amanda Smith.
Thank you, Joe. And thank you for the opportunity to present virtually. I'm sorry I cannot be down there today. So I'm going to kick it off by starting in section 5202 regarding exempt transactions. And we have two specific areas in here that we're seeking to amend. So this section pertains to the exemption of certain offerings from state registration requirements, and also contains a de minimis exemption in 14A. Specifically in A, what we're looking to do is decrease the de minimis exemption. So currently there's an exemption of 25 purchasers, and we're wanting to revise that number down to 10, which would be appropriate to the size of Vermont's small market. So Vermont is a Uniform Securities Act state, like the majority of other states. And this 25 purchaser threshold de minimis is typically something we see implemented in much larger states. So we, again, are wanting to reduce that number down to 10. By reducing this number, we don't expect an increase in the number of filings due to the change. I guess that's, it's an option, but we just believe that a reset is necessary that reflects Vermont's small market. And then, Joe, for some reason, I've lost the screen here, but as long as you guys can see me and hear me, in 14E, the current de minimis exemption also conflicts with our securities regulation in 4-3B1, and that regulation pertains to notice filing requirements for Rule 506 offerings. A 506 offering allows a company to raise capital through a private placement. So per our regulation in 4.3, sales of the offering in Vermont require the company to file with the commissioner a Form D filing and pay a fee of $820 within 15 calendar days of the first sale. So by adding E, we are indicating that 506 filings are not exempt from this de minimis exemption. So all 506 filings need to be filed with the commissioner. There's no exemption allowed. So there's a conflict between the reg and the statute. So does anybody have any questions about either of those?
I didn't quite catch what the Rule 506 offerings were that we would be not exempting. What kind of offerings again?
The 506 offerings Those allow a company to raise capital through a private placement. And when those sales are being offered in Vermont, they're required to notice file with the commissioner and pay a fee to do that within 15 calendar days of the sale. So because you have to submit your paperwork and pay your fee, there's no exemption allowed. So that our regulation in 4.3 regarding the 506 offering is conflicting with this statute, which is why we need to add E to say the issuer is not offering to sell securities pursuant to exemptions provided by Rule 506.
So this is to be consistent with federal law. Is that what you're talking about?
Yes, yes.
Okay.
Yep. So we're fixing the hole in the boat with number 2 there. And that clears that up.
Thank you.
Yep.
Question? Okay,
Okay, thank you. And then section 49, 5302, regarding notice filings, what we're seeking to do here is clarify that our fees charged are based on per share class, always have been, not based on portfolio. So making sure that that's accurate, and also adding in F that the fees that we receive are non-refundable.
good.
Okay. Section 50, securities registration filings. What we're doing here in little b is open-ended investment companies are federal covered securities, and those are exempt from state registration. We want to strike this sentence, open-ended investment companies, because it has no place being in this section, as 5305 pertains to securities registration filings.
Okay.
Okay. And then also in K, also clarifying that these fees received are also non-refundable. In section 51, I think you're there, Joe. Yep. All we're doing here is clarifying the name of the court to be consistent with the rest of the Vermont Securities Act to indicate Superior Court of Washington County. And then also continuing that in the last paragraph to also say Superior Court of Washington County on page 74 there. And then section 52, what we're trying to do, we're correcting a typo. In 33 VSA, the correct reference is 34, not 14, and 690234 defines vulnerable adult correctly. Yep. And then in section 53, I'm going to have Jennifer Rude, our Assistant General Counsel, talk to you about the change to this section. And I believe she's on.
I'm here, Amanda. Thank you. And
Thank
good
you,
morning,
Jennifer.
everyone.
Good morning.
Good morning. The requested change in section 5604E.
Jennifer, just for
Yes.
the record, can you state your name and affiliation?
Oh, of course. Jennifer Root, Assistant General Counsel, Vermont Department of Financial Regulation.
Thank you.
Okay, the requested change to section 5604E really is intended to codify existing practice. Under the current version of the statute, the commissioner is allowed to, and in fact, routinely does consider other factors, especially equitable factors. In other words, those designed to protect the public welfare rather than solely to punish. But the factors aren't spelled out, unlike other administrative penalty provisions in the Vermont statutes. And we started to realize this might be a problem when the U.S. Supreme Court issued a decision in 2024, SEC versus Jarkissi, which held that when the SEC was seeking civil penalties in a securities fraud case, the defendant was entitled to a jury trial pursuant to the 7th Amendment. And in that case, the court was looking at the SEC's penalty provisions and found that they appeared to be principally punitive in nature. So we started looking at what would happen if this issue came up in Vermont, and what would happen is the Vermont Supreme Court would look at it under the Vermont Constitution, and Vermont Supreme Court in a couple of cases looking at the penalty provisions in Title 10, which is environmental penalties, and Title 30, public utilities. Those two statutes have identical penalty provisions, and we are seeking to conform the securities penalties to those two statutes. The Vermont Supreme Court in two different cases found that those penalty provisions were primarily equitable in nature, so that there was no right to a jury trial. So it allows the department really to continue running administrative proceedings efficiently and consistent with prior practice. It just makes the penalty factors much more clear. It makes the department a little less vulnerable to jury trial claims, which really don't enhance administrative proceedings at all and make things much more efficient.
And so what we have here are the specific factors, Jennifer, I have this right, that are consistent with the other state statutes.
Correct. In each statute is number one is subject matter specific. So, the environmental one has this environmental specific factor, and in the securities one, we're considering the extent the violation harmed or might have harmed investors' access to capital markets or public confidence in the securities industry and the integrity of capital markets. That one is subject matter specific. All the rest of them are identical to the factors in Titles 10 and 30, which have been found by the Vermont Supreme Court to be primarily equitable in nature. And again, the department's always trying to protect the public welfare, so we think it's best if we spell out those factors and don't leave any ambiguity about what we're doing.
I'm sorry, can you repeat what was the Vermont statute that was the genesis for these factors?
There are two statutes that have identical penalty provisions. One is Title 10. It's 10 VSA Section 810 paren B, and the other is Title 30, which is public utilities, and it's 30 VSA Section 30 paren C. Are identical factors except for the first one.
Thank you.
Any other questions?
Oh, we're good to go.
All right. Section 54, back to Amanda.
All right, thank you, Joe. So Section 54 pertains to our Financial Services Education and Victim Restitution Fund, and we're seeking to clarify some of the victim restitution requirements. So specifically down to 1 in claimant, we are amending the definition of claimant and striking the rest of that language, which has been moved to the eligibility section. And then in item number 2, we are defining a dependent child based on the federal tax code, which will also is a part of the eligibility requirements on the next page. In number 3, you'll see through all of this, we're just cleaning up the language. The final order means an order issued by the commissioner, disposes of securities violations or claims. Also, changing the name to say Superior Court of Washington County to be consistent. Down in number 7, we're indicating vulnerable adult versus person, which is consistent with Title 33 regarding vulnerable adults. And also in number 7, as I had mentioned earlier, correcting a typo there for the reference to be 6902-34 versus 14. And then in C, we've cleaned up the eligibility requirements to make it a little cleaner to read. And number 2, we're saying that the commissioner shall not award securities restitution assistance under this section unless in A, the victim is a natural person who is a resident of Vermont at the time of that violation. Scrolling down to E, all we're doing is consolidating the statement further down to say if there is no reward of restitution in the final order or if the victim has X, Y, or Z. I got some renumbering and relettering there. And then down to number 4, replacing claimant with victim was a vulnerable, again, adult at the time of that securities violation. And then in number 5, A through C, all we're doing here is wanting to be very clear that we're protecting the information that we receive in that application. The applications that we receive contain PII, and we're just clearing up that information we receive is confidential. And I think the last, when we scroll down, Joe, to G, the state's liability for the award. We are again clarifying the commissioner's discretion with his ability to suspend applications and the discretion to be able to distribute award amounts based on the solvency of that fund. And
Amanda,
yes, please.
the protection of PII, does that also, are any of that information obtainable in the FOIA?
No,
request?
it would not be.
Okay, thank
No,
you.
it would not. Yep, you're welcome. Great question. I'm trying to see, Joe, where you are. The subrogation. Okay, the subrogation rights. Again, clarifying order to pay restitution to the victim. And number I, adding a new section here regarding forfeiture of that restitution award. If a person, person shall not engage dishonesty, forgery, fraud, and a person found by the commissioner or in a court to have engaged in those activities will be subject to penalties, etc. So, Joe, I think that's it for securities.
Other than section 58.
Okay, go ahead.
One question, Amanda.
Okay.
Person found by the commissioner or court, if the person is found by the commissioner, the court's still open to that person to read that?
That's a great question. I think that's something I should run by legal and get back to you on. I can do that this morning.
Thank you.
Okay, you're welcome. You're welcome.
And
So,
any other questions on section 54?
I think we're good.
Okay, the one other securities item is section 58, but I will walk through 55 through 57 really quickly, and then I'll let Amanda take section 58. So section 55, and these are truly miscellaneous. This is a change. You'll see a reference here to the banking supervision fund. Maria had identified this one for us. In this section, we make reference to both a financial institution supervision fund and a banking supervision fund in different places. We only have one fund for these purposes. It's the financial institution supervision fund. We checked, there is no banking fund with anything in it. And so this is just adopting the same name for both, since they are referring to the same fund. And so that's all we have in section 55. Section 56, we are moving the insurance regulatory and supervision fund. That happens in section 57. The insurance regulatory and supervision fund was in section 80 of Title 8. It was the only item in chapter 3. There were several other items in chapter 3 that had all been repealed. And where it was located, it was very close to the banking language, but it was just kind of lonely in its own chapter. And as we went back and looked, and each of the divisions has its fund language in the administrative section or close to it for that particular division. And so we are proposing to move the insurance regulatory and supervision fund language to the end of the administrative section in chapter 101. So it will be with the rest of the insurance administrative language. The other one, as we were looking at outdated laws, and thank you, Maria, for flagging this for us in 56B. Back in the 1960s, when the age of consent was 21, there was a state law passed that a minor 18 years of age or older would be eligible to take out a mortgage. That is simply outdated and clearly not necessary anymore. So we are proposing to repeal that. And then 57 is just moving the insurance regulatory and supervision fund that had been in the last item in chapter 3 to the end of chapter 101.
Same text,
Yes.
same provisions.
Yes. And then back to Amanda for section 58.
Thank you, Joe. In section 58, all throughout, we are updating the federal reference as what we had was outdated. And then Joe, in down to letter F, we are right there, letter F, we are adding the requirement for our investment advisory firms to maintain adequate insurance for the risk of a cybersecurity breach. In 2016, we included this requirement in our securities regulations and recently realized that it's also important to have this requirement codified in statute. So that's what this change is, in addition to updating the federal references. And that is it for this section.
Any other questions on securities?
Good.
Thank you all.
Okay, thank you.
Thank you, Amanda and Jennifer.
Thank
Never
you.
been through a bill so fast.
Thank you.
Take care.
I know, I hate to start over from the beginning. And then the last,
I thought we were done.
last item under that, section 59, effective date for everything here is July 1st. But now that we'll go back to section 1 with banking, I'll keep scrolling, but I will hand it over to Aaron to walk through the language.
Okay, great, thank you.
Good morning, everyone. Aaron Ferentz, Deputy Commissioner for the Banking Division at DFR. Thank you for having me. Just to get started, give you some themes. There's a lot of sections in our bill. A lot of them are sort of repetitive. We're essentially changing one term to another term. So for example, we have a license or a registration currently for a consumer litigation funding company. There really is no all of our enforcement activities and our work is related to licenses. So we want to switch that from a registration to a license. We maintain it within the nationwide multi-state licensing system. So there's a lot of themes like that where we're just essentially changing that one term for another. And there are a few other bigger, deeper pieces that we can talk about later. So Joe, in section number 1, this is Title 8. 2102. This is one of those examples where we're changing the term from a registration to a license. And then in section 2103, we've also added some language which strengthens our regulatory oversight of all of our entities. So we've added the language which says, and otherwise indicate that it is in the public interest to permit the applicant to provide services in this state. So this is before we have a licensee. We want to make sure that it is in the public's interest to allow them to do that business. There are some changes in terms of how the drafting works with corporations, limited companies, et cetera. Stylistic changes about his or her in terms of changing to person. At the bottom of page 4, there's an addition of a word, paragraph B there, which is consumer litigation funding company registration. That's something we missed. So that registration should be changed to license. You see that, Maria? In section 3, we have the change of control. So we've granted a company a license. We've granted that company a license based on our vetting of who owns the company or what the company does. If there is someone else, person who would like to acquire that entity or otherwise change who owns it, this gives the commissioner power to re-vet and go through a lot of those changes before it's So we're adding the seeking to acquire control of the licensee language to strengthen that. And this is in a section that applies to all of our licensee universe, not just the consumer litigation funding section. So mortgage lenders, money transmitters, mortgage brokers, all of the licensees within the banking division. In subparagraph B, we've added a specific reference to section 2202A of Title 8, which is related to commercial lender licenses. That was just something that was overlooked. Paragraph C, we've added the financial and business qualifier to experience, just to clarify that that's the type of experience we're going to be evaluating. And then at the bottom of the page there in paragraph E, we've added the language unless exempted by subsection F of this section. That subsection F is language which is related to money transmitters. Some of you were on the committee 2 years ago when we adopted the Money Transmitter Model Act. This is language that conforms to that Model Act. It's in this section and not the money transmitter section specifically because this is how we handle, again, all of our general licensing requirements. And so it's more important for it to be in this section than elsewhere. And these are just exceptions that the commissioner could by order or rule use to extend. These are more routine transactions that we don't need the power to go ahead and vet. So whether or not someone's acting as a proxy for voting shares, we don't need any sort of oversight of that transaction.
So the exemption, was that in regulation there or what's the genesis of the standards?
We adopted the Money Transmitter Model Act
Yeah.
2 years ago, and this is from that Model Act.
Oh,
And I believe it was just an oversight that it did not get added.
So that's the added was.
Yeah.
Thanks.
Let's see, there's just other stylistic changes in reordering because we've added those provisions. In section 2109, again, that's another example of the swapping registration for a licensee or a license, excuse me. Paragraph E, again, more stylistic changes made where we're saying, notwithstanding any other provision of this title to the contrary, etc.
What page are you on?
Let's see. Going too fast, still down, had a couple of copies. Questions on that one? Section 20 or section 5, which is subsection 2110. And this is language which is designed to give us more control over if someone has, pled guilty or had some sort of interaction with the court, which we would ultimately find detrimental. That if they have applied for us and then we find out this information about the court or the court order or the adjudication has occurred, gives us the powers to then take action as if it had happened prior, essentially. So this is more about, do they have the responsibility and the character and the competence to conduct activity. Still on page 11, Joe, subsection D, paragraph 1, that really lays out sort of the due process rights that if we were to deny a license or revoke or somewhat, take that from an entity, this would explain how they would appeal that. It would go to the commissioner and sort of give them all of those rights up to and including, I think, appealing to Washington County Superior Court.
One significant thing here in D2 is reason or reasons for instead of denial of the refusal or renewal.
Just going back up to the change to a felony change to, from the money laundering. Are there any felonies that wouldn't impact their ability to be in, I guess? I'm just trying to understand, like, it was very specific,
Right,
but super broad.
yeah.
I don't know, I don't know our statutes well enough to know what is a felony and what isn't a felony, right? So,
Yeah, I mean, I think that the language that we've removed there is a violation of a state or federal anti-money laundering statute. What if they were violating a state or federal fraud provision? We would want to know that and be able to take action. So that's why we've made it more broad in this particular case. Does that,
I'm wondering if it's too broad.
okay?
It's a question, it's not a, yeah.
Yeah, I mean, routinely we have a license for mortgage loan originator. So that's for the actual loan officer. Routinely, we have people within the last 7 years who maybe added DUI or some other really, very civil action, which we will just say, all right, that's not related to fraud or dishonesty or any of these other serious things. So we will not take an action against them or not permit them to have that activity. This strengthens our ability to say no to someone coming into Vermont to providing services or activities based on these activities.
Or, yeah, somebody who's already licensed and is it's conviction, right? There's something.
Yeah, this is specifically like pre-licensure. So it's sort of the period between they've applied for a license, but we haven't done anything yet. Then we can go ahead and still take action to the negative if we need to or feel we should.
Okay, so it's optional.
Yeah, it's not
a shall.
Correct. Is correct.
it may.
Yeah, the commissioner may deny, suspend, terminate, revoke, or condition.
Thank you.
Sure. Section 6, this is still in the general licensing provisions. This is in our exams and investigations powers. Paragraph K is referring to reports required pursuant to section 2120. We routinely get default hull reports from our licensees. And that hull report includes data that they report to us in terms of their activities within Vermont. We would like to make that confidential, subject to our exam powers, because that's how we're using the data. We don't want that subject to public records requests, because that is, again, exam related data that we're collecting on a regular basis. Helps us monitor the markets, helps us identify entities that may be doing things that we'll want to look into, either conduct an investigation or increase the frequency of the examinations that we conduct.
Anyone 20?
2020 is the section of statute that requires all reports or annual reports. So it's a bunch of proprietary data from the licensee about their activities. Any further questions? I will take the chair.
Just the language seems funny on line 8, the new language. Information obtained during or for.
Yeah, I think we've added the or for just in terms of, like I said, we collect this material routinely, so it may be.
Maybe a comma after the G.
Or maybe you don't need during.
You should obtain 4.
Yeah, I mean, during it's sort of like if, exams can go on for weeks or maybe months, so it's just that during that.
They put a comma. They're during. Up a little bit, at least for me. Yeah, but no, I think this has been through editing, right, Maria?
It has, but whatever.
Yeah, the comma's fine with me.
Yeah, I think it would read better.
Yeah.
Yeah,
Or just say.
Well, or if you could figure out if during is relevant. Right, if it's anything that's for an investigation, does that cover all of it or not? I don't know the answer.
Yeah, I mean, I think, maybe a question for legal. I don't know the true difference, but information we obtain during an examination certainly should be confidential, because that is, again, going to be proprietary information, have a lot of PI, et cetera, et cetera.
Is would be or if information was, or an official investigation was started, but information was being gathered, so that it wouldn't actually be during.
Yeah.
Yeah,
Before.
exactly.
That would.
That's the idea.
That's why it's added.
All right, section 7, again, this is one of those instances where we're doing a few different things. A lot of it though involves, at least one of them involves, changing registration to license. Changing company to person. And then just clarifying that this license, sorry, I should back up. This particular statute is specific to the consumer litigation funding license that we'd hope to change from a registration. So this just says that a person shall not engage in the business of consumer litigation funding without first obtaining a license under this chapter. And then we clarify that in addition to the information required by section 2102, which is again our general licensing provisions, an applicant for this license shall provide, and the licensee shall make at all times a surety bond or irrevocable letter of credit. Stuff that's already in statute. We're just clarifying. Section 8 is the consumer litigation funding company annual report requirements. We changed it from registration to, or registered to licensed. We're proposing to change, I should say. Moving on, Joe, to section number 9. These statutes are in our money transmission licensing, so very specific rules and statutes about how money transmitters should be operating in Vermont. That first paragraph, number 8, eligible rating means from shall means silent change. Same in paragraph 9. The language in paragraph 10 looks like it's brand new. That language is already in a definition, which is elsewhere within the statute. We've just moved it forward from that specific subsection to the beginning of this entire statute. So, because it is then referred to later on in other words. That's all existing language there. Let's see, on page 16, paragraph number 19 at the bottom, a money transmission kiosk. Had a lot of discussion over currency kiosks in this committee. This is a little different. So this is like a virtual currency kiosk would be specific to virtual currency transactions for cash. A money transmission kiosk would be something a step above. So it wouldn't necessarily have to involve virtual currency, but it could allow you, maybe Western Union puts up a machine that allows you to put in money to then send to a machine somewhere in Europe so your son or daughter could remove it. So this is clarifying with the definition of what a money transmission kiosk is. I do believe it does include the term, so a virtual currency kiosk would also be a money transmission kiosk for this language.
Again?
The term virtual currency kiosk, based on this new definition language, would also be considered a money transmission kiosk, and that's relevant to later on within the chapter.
The bill that we add in.
It
I
must
mean,
be-
I just
it
want
must
to
be
fire
in a
one.
Also, virtual current cryptocurrency isn't regulated anyway by
federally, right?
Well, there's a lot of actual federal legislation being debated as we speak right now.
Right.
Very
But
much.
technically, right now, it's not. It's
Sort of.
getting there.
Sort of. It's a lot of legislation around stable coins, but Bitcoin itself, no, it's not regulated by any. So any questions on that definition? Page 17, paragraph 20, shall mean, change to means. Shall include, change to includes. Page 19, another definition which has been moved forward, number 27, transfer. All that language is already in statute, we just again moved it to the entire definition section. Page 22, paragraph 33, another example. This is the virtual currency kiosk language. Again, it's just been moved elsewhere. Paragraph 34, we've strengthened and changed the definition of a virtual currency kiosk operator. So that means a person that offers, facilitates, or engages in whole or in part, directly or indirectly, virtual currency business activity via a virtual currency kiosk. As you might be aware, there's a lot of interesting business models on how these machines are being used. And so we're attempting to try and get as many of those varying business models within the definition so we can still regulate that activity. Sometimes the company that you're exchanging the cash for virtual currency may not own the machine. So we want to make sure this is all sort of clarified exactly how it's going on.
So I'm just being all against this morning, right? In terms of the crypto kiosks, that whole statute that we enacted, is that totally separate from this, or is this some interplay between what we're talking about with virtual currency kiosk and cryptocurrency?
These definitions are from that particular statute that we've already worked on. We've just moved them up here, and this is just strengthening those definitions as they're used in that statute that we've already worked on.
Right, and I can't remember the exact language of what we passed last year. But that chapter or subchapter, I can't remember. Those are the rules for crypto.
That's correct.
Yeah.
That's correct.
Not what this money transmission is regulated. That's close.
To be an operator of a virtual currency kiosk in Vermont, you need to be a money transmitter. So that's why it's within the money transmitter section.
Right, but does this statute grant any authority to a money transmitter to a crypto kiosk operator that isn't dealt with in the statute passed last year? I'm trying to understand the interplay between what we passed last year and this, general.
Yeah, it's my understanding that this just modifies that existing language that would have already been adopted last year.
This wouldn't necessarily apply to just like say Bitcoin or Coinbase is one I'm thinking of. I mean, if they wanted to do a fiat, then they would need to use a machine that's registered, use someone registered here, even though they're a completely legitimate company, you get stuff over the internet. I have an app for it, stuff like that, but this would allow a company like that to contract with a registered money transmitter, so I could go to an ATM and access money out of my Bitcoin account, or not my Coinbase account.
Yes, this would cover those unique business models that may crop up. That's correct.
Yeah, I guess what I'm trying to make sure I understand is this is independent of where you're getting from. This is just the transmitter. This is just it's like a credit card company. You have there's a clearinghouse there. And that's what we're talking about here, right? All they do is they transmit the money. They don't worry so much about where it's coming from or where it's going to.
So if you are exchanging money for crypto that can be then transferred to someone else, that is a money transmitter in the state of Vermont according to existing statute. And we're not
Right.
changing that at all.
Yeah.
And we're just clarifying the definition of who a kiosk operator would be. The moratorium would expire June 30th without any other legislation. So just anticipating that, we want to strengthen this language. Okay. On page 23, paragraph 36, again, another definition which we've moved forward from elsewhere within statute. All right, section 10. Another of the themes that we're attempting to accomplish with a lot of these changes is to clarify throughout Title VIII, the term financial institution isn't necessarily used the same in all areas. So we're trying to clean that up so that when we say financial institution, we don't mean other things than bank. So in this particular statute, which is section 10 and it's subsection 2506, we're declaring, excuse me, this is again within the money transmitter statute. That we need the name and address of any financial institution or credit union through which the applicant plans to conduct their money services business. So we're looking for, in this particular case, it should be a depository, and we need to know about it. Let's see, in 2507, we are clarifying the money transmission kiosk registration requirements. And so we've stricken some language and then added through which money transmission is offered, facilitated, or engaged in whole or in part, directly or indirectly, by or on behalf of the licensee. That's similar to a few sections ago where we were clarifying based on those business model changes. And then on page 25, Joe, is that paragraph 1. On a money transmission kiosk, we'd like the Vermont license number of the owner of the licensee displayed so that the consumer knows exactly who is the person that they have an issue with, so that when they bring it to our attention, we can work on that, address those concerns.
Determine how you want that to look.
No, I mean, it should be on the kiosk itself or on the screen. You know, it should be, I think there's language elsewhere that says it should be legible and sort of in a generic size.
We have a section that actually tells them that, or do we need it?
I believe we do. I'd have to double check.
Aaron, you said on the machine itself or on the screen, but this only talks about on the screen. Does it say somewhere else?
Well, it says on or at the location of the money transmission kiosk. So on or at the location. So it could be like a sign on the wall above it. It could be on the machine on the outside, or on the first screen. So it could be, you put in your whatever and it shows up there, but it should be displayed.
And we're finding right now that the other information is where it's supposed to be. So we're just saying, wherever you have all of the rest of that information.
That's correct. Yeah, this is more specifically about what type of information you want displayed. Section 12, this is another change related to the financial institution or credit union. This is in a section about our check cashers, our currency exchangers. It's a sub-form of the money transmission license. And similar changes are made throughout. Section 13, paragraph B, we're just striking that because we've already covered that by moving those definitions to the front of this chapter. And Page 28, again, this is one of this language that was moved forward. And again, on 29, that was also moved forward. In section 15, these are the banking consumer protection statutes that we have. And again, this is a good example of the fact that the term financial institution is used sort of, I would say, incorrectly, not completely, or it's different than it's used elsewhere. So what we've done is we've attempted to fix that by exchanging the term financial institution for regulated entities. So we then define regulated entities in section 17 as a person required to be licensed or chartered pursuant to Part 2 of this title, an entity organized under the laws of another state that is regulated by its home state in an equivalent manner to an independent trust company chartered to Chapter 77 of this title, a financial institution, a credit union, branches and agency of foreign banks and subsidiaries of any such person. So essentially, if the banking division regulates you, you're subject to these statutes. Let's see. And on page 31, Joe, to go back a second, paragraph 5, we've stricken the definition of financial institution again in place of this regulated entity definition. Questions on that or the reasons why we're doing that? Oh, sorry. Yeah, thanks, Maria. Going back, section 15, the start of these consumer protection statutes is 10-101. By making these changes, it's sort of superfluous. It's a little bit redundant, and so that's why we've repealed it here. Probably dates back to your time at the department, Herb.
Probably very much. So in other words, are the same provisions that used to be in 10-101 incorporated in the various sections?
They're essentially, yes, they're incorporated as they need to in the other various sections, exactly.
Same stuff.
Correct.
Good old days, sir.
I wish it would have.
What the good old days, that was there.
It's a good gig.
Did you find that there was confusion around who was regulated, or are you preempting?
It was certainly confusing for the non-legal folks, even within the division of like, all right, it says financial institution. What financial institution do we mean at this point? So, and again, it's more of a theme that we're trying to clarify specifically what we're asking for than just refer to everything as a financial institution.
I would also say at times it creates confusion across divisions in that sometimes a financial institution could be an insurance company, but it also could be a bank or credit union. And with those conflicting definitions, it's hard to know exactly who you're talking about. Whereas we know regulated entity, we know that it is someone in our jurisdiction.
So I forgot where we were, but
Section 18.
section 18. I believe all these changes are just related to regulated entity, and they are. Section 19 is the same. There's a lot of references there. Section 20, we've stricken some language there which references the authority provided by sections elsewhere within this consumer protection body of statute and just referred to in this title, because there are also other protections found elsewhere that would be applicable for us to use, powers, et cetera. Section 21 is about lead solicitation. So if any of you have ever applied for a mortgage over the last couple of years, the moment that that mortgage lender pulls your credit, you probably get inundated with phone calls and other communications from other lenders trying to essentially steal that business away. So this addresses, this statute attempts to address a lot of those concerns for the ultimate lender, and we've mostly made changes, I believe, regarding the change in terms from financial institution to regulated entity. On page 38, we've just again added some clarifications on the how you might resolve that by adding the civil division of the Superior Court language and Washington County, et cetera, because that's where we are. Questions on any of that language?
Can you talk about how that might change customers' experience with the lead solicitation?
Well, just as someone who applied for a mortgage recently, it would definitely clarify who I'm talking to when I'm on the phone, because as you know, you can get multiple inquiries and phone calls, which makes it confusing. And if we're trying to, protect our personal information, I don't want to disclose to someone who doesn't actually work for them, but has, slyly tried to sound like they are from the mortgage company. So a lot of these protections are for the bank or the credit union that is also doing that, so that their information is not misused, and it gives them particular rights about what they can do in that particular case.
I'm wondering, there's something that we can provide for the consumer also, right?
Yeah, it's so those leads are essentially being sold by the credit bureaus. So I think we get into FCRA, Joe, FCRA language that govern how those leads are sold. I'd have to think through probably in a separate way what we might be able to do in that regard.
That kind of like secondary business that the credit bureaus are operating. So I know that initially they're needed by financial institutions, regulated entities. But then they're moving that information to a secondary business of theirs and selling it.
Yeah, they're essentially selling the information that I've applied for a loan to anyone who'd like to buy it, that are just trying to fish and get customers for their own line of business.
Federally, there is a provision in the Fair Credit Reporting Act that the information can be used to contact people about credit and insurance offers. There is an ability for an individual to opt out with the individual credit bureaus if they do not want to receive credit or insurance solicitations, but it is a permissible purpose under federal law. The point that Aaron was getting at, so Fair Credit Reporting Act, the preemption of state law is very complicated. There are some things the states can do, there are some that they can't, and that's been sort of ever evolving. And so it is challenging to figure out with regard to the credit bureaus exactly what authorities states would have.
Okay. Moving on to section 22. This particular section is a specific thing only for banks. So that in the drafting, it got caught up in the financial institution regulated entity change. We would actually rather it be left alone, or more importantly, change the term person. So every person subject to the Federal Community Reinvestment Act would be a better fix. But the language as written should be stricken or fixed. Okay.
What language should we stricken?
In section 22.
Yeah.
Up on the screen, it says every financial institution is crossed off and put in regulated entity.
Oh, I see.
We don't want it to say either of those. We want it
Yeah.
to say person. And we've just clarified where the Community Reinvestment Act is found in federal law. Let's see. Sorry, section 24, lending reports, disclosures, and standards. So this is specific to lending activities. So it's going to be someone who's granting credit. So we've a regulated entity may not be the best term here as well. So in its place, we've used the term lending institution. And it's any person licensed, chartered, or otherwise authored or required to be licensed, chartered, or otherwise authorized under parts 2, 4, or 5 of this title is subject to it. So essentially, it's any licensed lender regulated by us or bank or credit union. And depending on the day, hopefully federal credit unions and national banks as well. Questions on why we've changed that? Again, as part of that theme of the financial institution term is used inaccurately in some spots. On page 42, we've added paragraph 6, which is just the definition of what a lending institution is. And we've referenced Vermont Financial Institution or Vermont Credit Union. Moving on, section 25.
Aaron, we say Vermont Financial Institution or Vermont Credit Union. We're talking about both state and nationally chartered.
There's a dual banking system. So, again, depending on the day, I don't know how the OCC, the Office of the Comptroller of the Currency, will actually interpret their federal preemption standards. So it likely is not something we could enforce on a national bank or a federal credit union. To my understanding, there are equivalent language within the National Bank Act or the NCUA rules and regulations, which would essentially prohibit the same types of discrimination.
Okay, so we're pretty much mirroring what the Fed does.
Correct.
But I think the original question, we're talking about Vermont charters here.
Yes. Let's see here. So section 25 is a body of law that's referring to home loan escrow accounts. So when you make your mortgage payment, you also add in an amount for the property taxes or the insurance. This just clarifies where those accounts need to be held. And it references federal definitions for banks insured by the FDIC or credit unions insured by NCUA. In section 26, we are clarifying subparagraph 2 that this is for financial institutions, and we don't need to have that language clarifying the definition further. Let's see. Paragraph 27, basic banking rules. And again, we're clarifying that this is related to only the Vermont financial institutions, the Vermont banks. And other stylistic changes. Section 28, returned check charges. So a return check would be if someone writes me a check and I go to deposit, it bounces, I cannot be charged a fee. That's a branch, right?
I write them all.
I still do too.
I'm old.
I just had to order something anyway. So just clarifying no depository institution and putting in place financial institution. And then let's see, section 29. Just talking about who this subchapter applies to, and it's any persons licensed, chartered, or otherwise authored or required to be licensed, chartered, or otherwise pursuant to parts 2, 4, and 5. Section 30, that is on, that whole section is on reverse mortgage loans. Does everyone understand what a reverse mortgage loan is?
I do. Very well.
I wouldn't necessarily say they're bad, but it's only be used for specific purposes. So what we've done here is we have just clarified the terms used throughout that particular body of statute. Again, theme financial institution to regulated entity. Any questions on the first section here, section 30? Section 31, before you can get a reverse mortgage in Vermont, you need to go through a counseling session, which explains the terms of the transaction and why it could be costly, et cetera, et cetera. So we've just changed the term from financial institution to person because there are non-banks that do offer these loans as well. Let's see.
So what's the interplay between federal law and reverse mortgages and what we have in our statute? It's the preemption issue or?
There is no preemption issue here. Vermont only allows what are called HECMs or home equity conversion mortgages. And those are offered as sort of a subset of HUD. There are other states that allow private label reverse mortgages. So, JP Morgan could do it with only their program, but Vermont only allows the federal sort of related version. Does that make sense? Let's see, section 31, changing a reference again to person. Clarifying the department. Section 32. This section just essentially says that you cannot, sell someone a reverse mortgage and then require them to buy an annuity. We don't want our older folks to be taken advantage of in these situations. So this is a consumer protection. We're just clarifying that no person and adding the term loan in there. Section 33, more limitations on reverse mortgage, just changing the term to person. Any questions on that? That ends the sort of general consumer protection area. And once we get to 34, we're moving into the actual sort of banking statutes themselves. Okay. In section 34, this is a definitional change and just a style change there in the first. Yeah.
This might be a good time to take a break.
Okay, sure.
So we'll take 15 minutes, give everybody a break, and then we'll be back at 10:30. Well, it doesn't look like there's a whole lot left.
No, there is not.